Advocates. All right, ladies and gentlemen, thank y'all for being here today. Ladies and gentlemen, we're going to go ahead and get started. If you'll take your seats. Ms. Ogden, if you'll call the roll.
Senator Albritton, Senator Bell, Senator Carnley,
Did you miss my chair?
Senator Coleman Madison, Senator Elliott, Senator Figures,
Here.
Senator Gavan, Senator Orr,
This is tearing up.
Senator Singleton,
Kids dry ride it.
Senator Smitherman,
Here, and good morning to all my colleagues who have had the chance to chat you. I'm coming to see y'all, by the way, in your offices. You know I am.
Senator Stutz, Senator Weaver, and Senator Barfoot.
Here.
And we have a quorum.
All right. Well, good. Well, ladies and gentlemen, I appreciate everybody being here today. The first meeting of the final session of the quadrennium. We've, started at 11 today. That's not going to be the normal time. We're going to go back to 8:30, but just for today, I know we'll see next quadrennium what happens. But anyway, as we get started, I'd just ask you to remember there's other committee meetings. I think the one that Senator Bell has and several committee members that are on that committee at 12 o'clock. So we're going to limit today to an hour. First up, SB 17, Senator Weaver.
Thank you, Mr. Chairman, and thank you for having this bill on your agenda today. We have done a lot of work on this bill. I think everybody in here is aware of why I am sponsoring this bill. There was a terrible situation in my district related to some extreme child sexual abuse, and our intent of this bill is certainly to address those really bad players. I understand that there are a few members who do have some concerns that we are able to fix in this bill, and we're working through that. We've been working all morning, but we're not at the point today where I feel like we have it fixed where we need to be. And at this point, I would like to ask if you would carry it over until next week to give us time to work through those few fixes that we're working on.
Got a motion to carry over by the sponsor, second by Senator Gavan. Any opposition? All in favor, say aye.
Aye.
All right, bill's carried over. Senator Weaver, we'll get that gets you back and that topic back on the agenda very soon.
Thank
Mr.
you very
Chairman.
much.
Thank you,
Mr.
Senator.
Before you move forward, may I be recognized?
Yes, sir. Go right ahead.
Senator, would you and I find a way to get together so you can give me a clear understanding of the definition of sexual torture?
Absolutely,
Okay.
and I'm happy to do that, and trying to do as much of that one-on-one with members to address their concerns so that we're able to address that and bring it in here with our resolution as we do that.
All right, thank you.
All right, next up, Senator Elliott, SB 20. It looks like there's an amendment.
There is, Mr. Chairman. I'll kind of introduce the bill, and then Senator Weaver has fixed my bill, so I think she's got an amendment for that one. So she may not have fixed hers yet, but she's got mine fixed. This is very simple, and it basically makes a Class C felony assault in the second degree if you assault a public official. And so in my district, I have had, unfortunately, a couple of instances where people have gone after city council people and et cetera. This is providing the same protections for public officials that it does for EMS, firefighters, police officers, et cetera. And so that's existing law. We're just adding public official to it. And then, again, as you mentioned, we've got Senator Weaver's amendment.
All right.
I do have an amendment, and basically my amendment adds pharmacists and nurses that work outside the home. So it would be for home health people and people who are working outside of a clinical setting. I have had the amendment drafted. I don't have the amendment in hand. So if I'm fine, if I know that you're willing to take that amendment, and I'm okay with amending it on the floor if you're okay with
Works
doing
for
that.
me.
Is this your amendment? because it should be in everybody's packet.
Yes, that is my amendment, and I would like to offer that.
Okay,
Good staff work there.
Yes,
Mr. Chairman,
thank you.
Senator Figures.
before you go through with that, when you bring up certain people in the healthcare profession, I've been watching The Pit, and on one episode it was shown, and I have forgotten how a lot of health officials, healthcare professionals had been assaulted when they can't get help and the backup of care in emergency rooms and waiting rooms and all. So I was just thinking that if you could change it from just certain health professionals, but all healthcare professionals, because a doctor may have to go out and do something or whatever, but not just pharmacists. But does it take care
So
of
we
that?
originally had the felony assault bill, and I carried that when I was in the House, and that
Okay, so
covered
that
people like
encompasses
like
it.
in the hospitals and the ERs and that sort of thing.
Mm-hmm.
And it's been amended many times over the years.
Mm-hmm.
This time, when Chris brought it back up for public officials, we had the discussions because it had not included pharmacists and healthcare workers outside of the clinical setting. But
Okay.
I think all those
So
people
this
were
would take
covered.
care of this?
I'm pretty sure everyone else was covered on the original bill. I don't have it in front of me, so I'm not
Okay.
not sure. But
Okay.
if it's
Well, we
not,
can find out, and if I need to amend it on the floor, Senator Elliott.
Yes, ma'am. Absolutely.
but I'm pretty sure we already addressed that.
Okay. Thank you. Thank you, Mr. Chairman.
You're welcome. Senator Coleman Madison and Senator Stutz.
Thank you, Mr. Chair. And I just spoke with Senator Elliott. The question that I have, the inclusion of social workers, and these are people in particular that work with DHR, that go into homes, they're out at night, and I would like to add that as an addendum on the floor to make sure that they are covered.
Sounds good to me, Mr. Chairman.
Senator Stutz.
Thank you, Mr. Chairman. I'm assuming all this is doing is raising the degree of assault for these special categories of people.
Yes, sir, and it's important to note that this is the actual act of assault. There's some other bills floating around that have been in the press that deal with speech and some First Amendment things that I want to stay away from, but this is the act of.
Makes it a second degree instead of a third degree if you're in one of these protected categories.
Yes, sir, makes it a Class C felony.
Senator Albritton.
I'm going to vote for the bill, and I'll vote for the amendment. But I want us to be aware that we're creating another specialty class of people and expanding it to a whole number of people. And I bet you there may be more additions of people defined to get added to this. Government is already becoming a fortress and isolating itself away from people, and to make government workers or whatever more of a protected class, that just seems difficult for me to handle. But I'll support my colleagues on this. But I think going down this road is not going to accomplish what we want to do, which is a protection of people. But I'm afraid it will have a detriment effect as to what government is and is not. So anyway, I'll shut up on that one.
Let me kind of echo what I think Senator Stutz and Senator Albritton's position may be, is that I have in the past voted to add different categories, reluctantly voted to add those. I do think it's more about the intent, the mental intent of what happens and the consequences, as opposed to a specific category of people. So I, like Senator Albritton, will vote to get it out of committee reluctantly because I do think when you start putting people in a certain classifications, treating them above or differently than others, then that's a potential problem. Senator Figures and then Senator Stutz. I do. Senator Figures and then back to Senator Stutz.
Thank you, Mr. Chairman. My concern was the word former. How far back former do you go? And do you have to at least prove that the assault was connected with the position that that person held? That would be a concern for me.
Valid.
Yeah. Or even just any former.
If I may, I think she's just trying to protect Jabbo.
Senator Stutz.
Thank you. That was my concern. Senator Elliott, and I'm, as a public official now and as a healthcare worker, I mean, I fall in two of those categories, and I'm kind of opposed to creating special categories. Beating me up is no worse than beating up somebody else. So I'm not in favor of creating special categories for people to get assaulted in.
All right, back on Senator Weaver's amendment, there was a motion. Did you have a motion to adopt that? Second by Senator Elliott. Ms. Ogden, if you'll call the roll for me. This is on the amendment.
Senator Albritton? Senator Bell? Senator Cornley? Senator Coleman Madison? Senator Elliott? Senator Figures? Senator Gavan? Senator Orr? Senator Singleton? Senator Smitherman?
Aye.
Senator Stutz? Senator Weaver?
Aye.
Senator Barfoot?
Aye. All right, the amendment is adopted. Back on the bill itself. Any other discussion on the bill as amended? All right, Ms. Ogden, if you'll call the roll. We got a first by Senator Elliott, second by Senator Weaver. Is that right? On the bill itself as amended. Ms. Ogden, if there's no other discussion, if you'll call the roll.
Senator Albritton? Senator Bell? Senator Cornley? Senator Coleman Madison? Senator Elliott?
Aye.
Senator Figures? Senator Gavan? Senator Orr? Senator Singleton? Senator Smitherman?
Aye.
Senator Stutz? Senator Weaver?
Aye.
Senator Barfoot?
All right, the bill's given a favorable report. Thank you. All right, next up. I can turn my paper over. We've got SB 24 by Senator Coleman Madison.
Thank you, Mr. Chairman. This bill has been around for a while. We did pass it out of the Senate last time and got it down to the House. Basically, this is voter restoration of rights of persons who were already registered voters that have served their time, met all the qualifications, and now have to go through a certificate of certification. And this would allow the Secretary of State's office, working with Pardons and Parole and the Registrar's office, to provide notification that they have met their qualifications and they are eligible to vote. The question is that we are tweaking this bill, so I don't want to carry it over, pass it today. We are making some amendments to comply with requests and concerns of Secretary of State's. It says that you have to send a notification to the last known address. Well, someone's been in prison for 5 or 6 years, their last known address is not the same. We don't want them sending out notices and then it having to come back. So we're gonna make some amendments to just say, it just requires for them to put it on their website. And then it is the obligation of that person to go to that site to check to find out if they are eligible to vote. So with that, Mr. Chairman, if there are no questions, I would like to carry the bill over
Okay.
and work with them on this so that we can get this in. And that was the only concern that they had.
So moved.
Second.
Motion and a second. All in favor say aye.
Aye.
All right. Ladies and gentlemen, I do think it's important to note when that bill comes back up that we did pass that, I believe, unanimously last year out of this committee, and it did get a floor vote, and it passed, I think, overwhelmingly. And that is a bill that does, as you said, does not change the requirements to be able to vote again. It's just notifying those who have met those requirements,
Right.
the notification part. And I appreciate you working with the Secretary of State's office on
Thank
that.
you.
All right, next up is SB 25, Senator Weaver. Another bill I believe we had last year as well.
Yes. So thank you, Mr. Chairman. This is another bill that we are still making some tweaks on. And for the sake of time, instead of working through it today in committee, I'd like to continue to work on that and bring it back to committee next week. So I'd like to carry this one over next week, too.
Motion carryover is first by Senator Weaver, second by Senator Gavan. All in favor say aye.
Aye.
All right, bill's carried over, and we'll get back to that.
Mr. Chairman,
Yes, sir.
could I be recognized?
Yes, sir.
I too would like to make sure that we can get together before
Okay.
next meeting. Thank you.
All right, next up is SB 30, Senator Woods. Senator Woods, welcome to Judiciary, this time in your role as a senator rather than a House member, but glad you're here.
Well, thank you so much, Mr. Chairman and committee. It's good to be here with you today as a member of this august body in the upper chamber.
Good
All my
start.
friends in the House who are listening. I do appreciate the opportunity to present SB 30 at this committee at the first meeting of the year, so thank you for putting me on the agenda.
Yes, sir.
This bill we've named Trey's Law in honor of Trey Carlock, who was a victim of sexual abuse at a Christian sports camp in Missouri over a period of several years. After his abuser was sentenced to 3 life terms in 2010, Trey pursued justice to hold others involved accountable through civil litigation. The re-traumatizing process ended with a settlement agreement that included a restrictive non-disclosure agreement, barring Trey from ever speaking about his abuse and the camp's role in it. Sadly, at age 28, Trey died by suicide after telling a therapist, "They will always control me, and I'll never be free." To quote Trey's sister, Elizabeth Carlock Phillips, who I will say is a remarkable young lady who is up for a finalist as Advocate of the Year in the state of Texas, "The use of NDAs and settlement agreements is essentially lawful hush money. It is institutional abuse on top of sexual abuse. NDAs are legal mechanisms that were created to protect trade secrets, not trauma secrets. By passing this law, we can make a statement that silence is no longer for sale in the state of Alabama. We certainly would not be the first state to pass this law. Just last year, Texas passed this law unanimously. It was signed into law by Governor Abbott. While 18 states in the U.S. Congress via the Speak Out Act have clarified the law on NDAs for witnesses and adult survivors of sexual harassment in the workplace, only a few states so far have legislation specifically prohibiting the misuse of NDAs in civil child sexual abuse settlements, rendering them void and unenforceable. I do believe very strongly that this bill is the right thing to do for sexual abuse survivors and victims. It provides them with control over their situation and allows them to heal without suffering in silence. Specifically to the bill, I will point out in lines 50 through 55 on page 2 that this provision of any agreement that prohibits an individual from disclosing sexual abuse or facts related to sexual abuse would be void and unenforceable. The bill in no way prohibits the confidentiality or other aspects of a settlement agreement, including settlement amounts, which you can see in line 58 through 61. Perpetrators and negligent institutions use NDAs to prohibit survivors from ever speaking out about their abuse or discovery in civil cases. NDAs in civil sexual abuse, sexual assault, and trafficking cases protect perpetrators and negligent institutions. It conceals abuse and discovery from the public. It harms adults and children who unknowingly are allowed to interact with bad actors. And it prevents justice and healing for survivors by inhibiting freedom to share their stories. This bill is very personal to me. Trey has family members who live in Walker County in my district who reached out and asked me to look into this law that they are advocating across the country. It's actually passed in Missouri and Tennessee as well. And reading his story and hearing the tragic outcome for Trey made me really question what are we doing to protect sexual abuse survivors here in the state of Alabama. And I would respectfully request your support for this bill and happy to answer questions.
Senator Woods, I just want to say, you know, the conversations we've had over the past couple of months, I know you've been an advocate for this and stand here today, and I can see the passion, and I appreciate you bringing this to us. I know there may be some discussion about it, and we'll start off Senator Smitherman.
Senator, you know, we had started talking about it, and you were explaining it to me prior to coming. One of the questions that come to mind is that the non-disclosure agreements, is there language in the bill that establish a division of its applicability in terms of the type of cases you just talked about versus in the business setting where it's, like, as you just said, that it was basically established to deal with those kind of issues?
Right. No, sir. This is supposed to specifically be for sexual abuse cases that are civilly settled, already settled and negotiated in a civil settlement agreement. It does outline that. Yes, sir.
It's in the bill.
Yes, sir.
It does that.
If it's not, we'll put it in, but to my knowledge, it's there. Yes, sir.
All right. Well, Mr. Chairman, at the proper time, when everybody get through, I'd like to move for favor report on it.
Okay, Senator Albritton and then Senator Coleman Madison.
Thank you, Mr. Chair. Senator Woods, appreciate you bringing this. This needs to be discussed in many ways. Do you know if the perpetrator in that particular case you're talking about, was there criminal activity, a conviction in
Yes,
regards to
sir.
this?
He was sentenced to 3 life sentences.
3 life sentences.
Yes, sir.
And after that criminal conviction, civil conviction was taken in against him or something.
Against the camp that allowed
Against
him
the
to
camp.
continue to be
Okay.
a part of the camp after they had evidence that he was doing things he should.
All right. That's an interesting matter that's there because this was not a restriction. The NDA did not involve the perpetrator at all. Is that correct?
I can't speak to the details. because I don't know.
Normally an NDA, from my limited experience here, is that the NDA is to try to protect the entity or the institution that's involved with this,
Right.
not the individual.
Right. Well, I
Okay.
think this would be applicable to institutions, certainly.
That's my
yeah,
point.
yes, sir.
This is more directed toward the institutions rather than on the individual.
I think it
Because the
could be-
individual is serving prison.
In that case, yes. This
Okay.
is not going to do anything on the criminal side, changes no penalties or procedures whatsoever.
Exactly. My concern is that this, if we remove this in Alabama, that's going to make it more difficult to come to any kind of a settlement in these matters. That then throws it into an open jury, an open court, which is more traumatic, and/or it throws it directly into criminality. So I'm hesitant to jump on this wagon right now until I get some clarifications as to what circumstances that may. Sometimes an NDA of that nature might be appropriate, and banning it completely, I think, is an overstepping, because the institutions. Maybe there was neglect, maybe there was other issues that's there. Those mostly can be corrected. But sometimes these nonprofits, these entities, do good things very well. There's I miss the Boy Scouts, all right? And I miss other entities that get caught up in these matters because of the individuals that are involved. Anyway, I've got some hesitancies along this
I'm
line.
happy to talk with you about it further and can offer some more context if you'd like.
And let me just, before we go to Senator Coleman Madison, I think I understand and agree that there could be some on the civil liability side. I have a concern that an individual or a victim of that may not be able to resolve that case if there's not a non-disclosure. So I can certainly see what you're saying there.
May I speak to
Yes, sir.
that before, from the next question? And that's a great point you bring up. I don't think anybody in this room would ever want to see a victim not be made whole as much as possible. Certainly, I would agree with that. And there's a question that I brought to the tracelaw.org group. And so on their website, it actually provides a lot of data and research that speaks to any diminishing settlement amounts. And their research has not been able to provide any evidence that settlements were reduced in any form. Matter of fact, I've got a little bit of that information from some Texas-based attorneys that refuse NDAs as part of their trauma-informed legal practice. And one says, I've never in 30 years of practice had a deal blow up because of this issue. Another says taking NDAs off the table actually helps with achieving a better settlement amount because opposition cannot hold that over the victim's head in the negotiation process. It's also been brought to my attention that sometimes a victim's own counsel will encourage them to request the NDA to try to get more of a settlement. When that's off the table, you got to come to the dollar amount faster.
Yeah, I appreciate you addressing those issues. Senator Coleman Madison and Senator Figures.
Thank you, Mr. Chairman. I think Senator Albritton's question alluded to where I am, but I can see this as being a benefit going back to the Me Too movement, as far as trying to address this. But this would have had to been in place prior to. But at least if it's out there, hopefully, there's a lot of things in this. It's a big print that grants it. It's a small print that takes away, and that's oftentimes what people miss and don't read. somehow in this non-disclosure, it needs to be, bold and highlighted, so that people can see this and going into a lot of situations. And I don't know how the contract will be actually written up when this is all finally put into draft and into law. But to be effective, I think it does need to be something that is bold so people know that they have that right. Otherwise, they'll still sign their rights away and not know it.
Especially in the case of a minor. They don't understand, and they think that they have to do this, and they don't, even if this passes and it's unenforceable, people will still try to get them to sign into it to silence them, not knowing that it's not unenforceable.
Well, not
They'll
just
trick them.
minors, it can be adults as well.
I just want to point out before we go to Senator Figures, I understand this is not retroactive. It does not have any place to undo any of those.
No, sir, I will
previously.
say now, in Texas and Missouri, it was retroactive for all time, and I did not go there with this bill whatsoever. There's no retroactivity.
Senator Figures.
Thank you, Mr. Chairman. Senator Woods, thank you for bringing this bill. I think you cannot put a price on a person who has gone through trauma, particularly a child. And to me, part of the healing process is to be able to talk about it. And then I think about in them sharing their story, they can help so many other people, that they could help other children as well on things to look out for or whatever. So I approve of this, and you have my total support, and I thank you again for bringing it.
Thank you so much.
Thank you, Mr. Chairman.
Thank you. Senator Bell.
I think my questions got answered because basically what Senator Smitherman said, and at the appropriate time, I'd like to follow him and do the second on it.
Okay. So we did you make your first? Okay. Senator Bell's a second. Any further discussion? Senator Albritton,
Yes, sir, if I may make one.
recognized for discussion?
Yeah, just
Yes,
one
sir.
quick point.
Yes, sir.
We emphasize the degree, if there's a child, a minority, someone who is unable or to handle make these decisions. Keep in mind that in a court proceeding like that, usually, in most cases, that individual is going to have a guardian ad litem to protect their interests. They're going to have a parent also that's there, or guardian that's going to be there. Plus, the court, the judge, has to make an approval on this matter also. So there's protections there that go in to make sure that this is done. And in most instances, too, in those matters, they're going to have tests and analysis and such, psychologists and others involved. So it's not like it's a matter that they're going to be pushing a child into the corner and forcing them to sign a document. I just wanted to defray that issue.
Thank you for that clarification, because you were correct. Senator Elliott?
I don't want to belabor the point, Senator, but I agree with Senator Albritton and his concerns. The day is young.
Yeah.
Yeah, I think we may negatively impact settlement amounts with this. I think, and I appreciate you addressing it, but I still have that concern, and I'm worried that the consequence may be, when we're talking about not the offender, but rather an entity that certainly has liability. But I'm concerned that we're really going to negatively impact settlement amounts.
Mr. Chairman.
Senator Figures.
And most of the times, the only person that's going to be concerned about those settlement amounts are the lawyers. So, as I said, there's no price you can put on a person's peace and stability of getting over a trauma like that. I just wanted to put that out there.
Thank you.
If I may make a comment.
Yes, sir.
To that, and I was hesitant to bring this up, but California's actually had a similar law, not Trey's law, for a number of years. And, of course, according to the organization that I'm here on behalf of today, over 30,000 cases in California where NDAs were banned as part of the STAND Act related to sexual assault. Indicates the elimination of NDAs does not seem to have depressed settlement sums. I can't say it's absolute, but that was a 2025 study. And to Senator Figures' comment, which I appreciate, the psychological benefit of negotiating a larger settlement amount in exchange for silencing a sexual abuse victim does far less to promote healing and allowing that victim to disclose their abuse to others. I'm here on behalf of Trey and his family. I don't think if Trey received 10 times what he received, it would have changed the outcome of him taking his life. But if he could have talked about it, he might could have healed and got past that, and that's something money can't buy.
And
Thank
there's
you.
no amount of money that would make that person whole.
No.
Ms. Ogden, if you'll call the roll for me.
Senator Albritton? No. Senator Bell? Senator Cornley? Senator Coleman Madison? Senator Elliott? Senator Figures?
Aye.
Senator Gavan? Senator Orr? Senator Singleton? Senator Smitherman? Senator Stutz? Senator Weaver? Senator Barfoot?
Aye.
11
Senator,
favorable.
Senator Woods, Bill's giving a favorable report. Thank you, and appreciate your advocacy and passion on that topic.
Mr.
You're actually next up on SB 31.
Mr. Chairman,
Yes, sir.
I feel like I've been here for a minute already. Okay.
Let me, one second.
if it's acceptable by Mr. Chair, I'm gonna vote favorable for the next two bills, but I'm gonna have to leave. You know, they're having a spouses thing across the street. 45 years, I'm going across the street.
Don't miss it.
By the time I get back, y'all might be through.
Just for,
You know.
just for the, so my understanding is your intent, if we vote on the next two, which is SB 31, which has two amendments, and SB 41, you're a yes on the amendments and yes on the bill itself. Is that correct?
Well, I'm gonna vote on the bill. I don't know the amendments.
Okay,
You know, so, but if the committee has enough faith in them, then I'll vote on the final passage of it.
Very well. Thank you.
Okay.
All right, Senator Woods, SB
right.
31.
Well, to continue the trend earlier for bills that have passed, this bill had passed this committee last year, passed through the House unanimously, went through committee and didn't make it to the floor. This bill is related to our terrorist threat law. It provides practical safeguards. It enhances some penalties for those who would commit this crime. It provides a definition of a credible threat. It removes the credible threat from a classroom situation if it's a student who commits this act, requires them to undergo a psychological evaluation and appropriate counseling before being eligible to be readmitted into a public school. It also provides opportunity for restitution to be ordered on the part of the guilty party. We see specifically on school lockdowns, the law enforcement response, emergency responders, the school itself has a lot of expense associated with responding and clearing the school grounds and making sure everyone's safe. But it also takes these folks away from actual emergencies in the community. Last year in committee, Senator Singleton, I know he's not here with us, had a question about the uncapped restitution amount.
Let's go on the, get on the First Amendment. It's a technical amendment.
Okay.
And I believe that's your amendment, and it replaces the only thing it changes is the date or the
Yes.
year.
It changes
to
the year.
2026.
That's correct.
And I'm gonna offer that. I've got a second on that. Any opposition to the First Amendment? It should be in your book there, changing the year to 2026. Okay. No hearing, no opposition. That amendment is adopted. Second amendment, I believe, is Senator Coleman Madison. Is that correct? Yes, sir. Should be in your packet.
I move.
Got a motion to adopt Senator Coleman Madison's amendment?
If I might speak to the amendment.
Go right ahead.
Senator Nicole Madison, I appreciate you bringing this to me before committee just a little bit briefly. At this point, I would not be interested in accepting this amendment, but with the understanding that I'm happy to continue discussions. I haven't had a chance to review this with stakeholders. It would have changed the definition of a credible threat in a way that I want to understand the consequences of. If you would be willing to allow us to continue to have that dialogue before we get to the floor, would that be acceptable?
We will hold on to it. Do check, because what this lacks is specificity as far as when someone makes a threat. I mean, when you start talking about young people and language, we're going to have to start having a law class for kids in school. It's gotten to that point. If we are going to impose these things on them and they don't fully understand what their rights are or what they are saying that can get them in trouble, if you have administrators, and more teachers and administrators are being put under the magnifying glass to enforce, abide by the laws that we pass. And so I can see us inadvertently penalizing a child, cutting their life short, based on a silly, just out of the moment anger, happens to all of us. We say things down here. And so without being specific on this, somebody just makes an idle thing, neighbor against neighbors, fighting over nothing. You threw that piece of paper on my lawn. I can see that it's going to cause some problems unless we try to get some clarity on this.
Senator Coleman Madison, I understand you're willing to withdraw that amendment and continue to work
I
with Senator
withdraw.
Woods on that. Is that correct?
I'd like to continue to work with him on this so that
Okay.
we can be specific when we put this out, and people will know what they can and cannot be charged with.
Okay, we're on the bill then as amended with the technical amendment.
Mr. Chairman.
Senator Smitham.
Just to be procedurally correct, I'll withdraw my motion for it to pass.
Very good. That amendment then is withdrawn. I'll second that. All in favor of withdrawing the amendment, say aye. Aye. All right. Amendment is withdrawn. Senator Orr?
I just seconded Senator Smitherman's favorable motion.
Okay. We're on the amendment, the bill as amended, to have a first by Senator Smitherman, second by Senator Orr. Unless there's any other discussion, Ms. Ogden, if you'll call the roll.
Senator Albritton? Senator Bell? Senator Carnley? Senator Coleman Madison? No. Senator Elliott? Senator Figures? Senator Gavan? Senator Orr? Senator Singleton? Senator Smitherman?
Aye.
Senator Stutz? Senator Weaver? Senator Barfoot?
Aye. All right. Senator Woods, good job.
Thank you so much. Appreciate your
Yes,
time.
sir. All right, next and last up, it looks like SB 41, Senator Kelly. I believe this is a bill that we also had last year, if I remember correctly. Thank you.
Second.
Got a motion for favorable. Okay. Second by Senator Bell. I think there will be a need for some discussion. Senator Kelly, if you'll just tell us really briefly
Hello, Judge
what the
Smitherman.
bill does.
Yeah, I'm a little bit concerned. I'm not sure if I'm in the twilight zone. I've seen two of my fellow senators agree with Senator Albritton. I don't know that we've experienced that in this body before.
A little different.
Oh, was it? I mean that with all love and concern, Senator Albritton. No, this is an elder abuse bill. The bill would provide that an individual who is convicted of elder abuse or financial exploitation of an elderly person may not receive benefits under the abused or exploited individual's will, or if no will, through the intestate succession, losses, or her property interest or any joint tenancy held with the abused or exploited individual. May not receive any benefits whatsoever. That is after the convictions, and I can tell you this is something that's close to me. It has come before this body last year and did pass out of this body last year. And this is on the rise, and I've had to deal with it personally, ironically, more than once.
Thank you. Got a motion for favorable and a second already. Senator Gavan and then Senator Figures.
Well, thank you. So I understand your intentions here. I want to point out a couple of things, and I guess I was asleep at the switch last year. But I've actually handled a case, not with financial exploitation, but actually with felonious killing of someone and dealing with the resolution of things that fit in here. And one of the things that we deal with is kind of compounded on this a little bit more. I mean, we're not going to see it that much in a murder situation. I mean, it does happen, but I think there's maybe more chances for this scenario to happen. But real estate's got to vest in somebody at all times. And so this basically gives, I remember my mentor coming to me when we had a pretty famous murder situation in Huntsville, coming to me going, how are you supposed to know if you're doing the real estate closing, because it could be later that this comes up. And so I think that's even compounded more perhaps on the financial exploitation site. But one of the things that I want to point out is we start out in the synopsis of talking about a conviction for elder abuse, but if you get down on at the bottom of page 3 on line 83, it says in the absence of a conviction. So this is leaving open a back door to me to have a civil case later.
Okay.
And I think that we need some work on just clearing that up. And then, I can come up with a scenario where, like on the bank accounts, I mean, first of all, I think it's going to be kind of hard to maybe deal with this because you could have a situation. I mean, if you've got a joint bank account, if I have one with my wife, I can write a check for every penny of it and drain it immediately. So can she. So I don't know. I see this being a little bit problematic there. I also see a situation where, because what you've got is a situation that where the joint bank account would be severed, and they would be limited to only keeping their half interest. So you did put that in there, but what if all the money was put in by the financially exploited person? Then there's a windfall to the exploiter, or vice versa. Let's say I put all the money in an account and I'm later guilty of exploiting the co-tenant in that. I put all the money in, and yet they would get half of it. So I think that it's great intentions. I'm just a little concerned about things in the weeds, but the biggest point I've got is on the conviction language, because that's the way it starts out, is it's going to be a conviction, which is beyond a reasonable doubt, but then there's sort of a gray area there that I mentioned on page, I think it's page 3. But anyway, so I'd like to work with you on that. I will vote for it to get out of committee.
Yeah, be glad to work with you on that. We want to make sure it's good and clean with no unintended consequences.
Committee members, I'd ask you to appoint you to our attorney, Mike Harper, also noted that, as well as potential language, an additional legatee, which is just a term of art, legal term, to add that in. And Senator Gavan, if you're going to be working with Senator Kelly, I'd ask you to try to incorporate that as well. Any other discussion before we take a vote on this? All right.
Mr. Chairman, I just want to say, I really hope that we get this right. This is an issue that's not going to go away, and it impacts a lot of people, in particular elderly people and those who are disabled or what have you, and maybe have someone that they trust. And many people have been impacted by it. So I'm just hoping that we work with whatever entity and not just rush to it. I think it's a great bill. I want to thank you for bringing it. I'm sure that we can all associate or remember someone that might be impacted by it. Who knows, we might be impacted by it one day. So that's why it's very important that we do get this right.
Agree. Thank you. Senator Studs?
Thank you, Mr. Chairman. What happens, maybe some of the lawyers here, if they're the only heir in the estate? I was thinking about the joint bank accounts and stuff, and I wasn't going to say anything else because you kind of brought that up. But then as I continued to think, if you can't participate in the will, say it's an only child, they're the executor of the will, but they get convicted of abusing their elderly parent, and they're the only heir, or what happens? The court just take it over,
Well,
who do they give it to?
I think ultimately,
We'll go through a process. I mean, you might have I've had some parents that didn't want to give their kids a dime. And so, whether it was going to go to a charity or in their will or go to cousins or whatnot, but if they were cut off, then the state of Alabama's got I tell people all the time, the state of Alabama's got a will for you. It may not be a very good one, but they've got one in those black books that we got in our offices. And it basically, it looks up to the parents, and the parents are deceased, and it's going to flow down to the brothers and sisters and nieces and nephews, and it goes up to grandparents and flows down. And if there's nobody at that point, it's going to go to the state of Alabama.
all right. Thank you for bringing that up. I will add that if there's a will that, if there's a contingent beneficiary in that will, then that's who that would go to, regardless of if they're part of the family or not. So, Ms. Ogden, if you'll call the roll.
Senator Albritton? Senator Cornley? Senator Coleman Madison? Senator Figures? Senator Gavan? Senator Stetz? Senator Weaver? Senator Barfoot?
Aye. All right, Senator Kelly, bill's given favorable report. Thank you for being here. Ladies and gentlemen, that concludes our business today. Motion to adjourn, do I hear a second? Second. So got a second by Senator Figures. All in favor say aye. Aye. All right, see y'all next week. Thank you. We are adjourned. Thank you.
There's always next week. Now you get started.
Sorry. No,